Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On August 11th, 2025, Brian C. Kohberger will stand trial for 5 felonies that he has been charged with indictment by the grand jury of Latah County, where this case was proceeding up until change of venue, when the court in Latah County, Judge John Judge, granted Mr. Kohberger's motion for change of venue, which he filed originally on January 30th, 2024. It was granted in September of 2024. The Idaho Supreme Court found that the case should be transferred to Ada County and that the Honorable Judge Stephen J. Hippler would then be the trial court proceeding this case, to which this case would proceed under. The 5 counts that Mr. Kohberger will face trial on are located in the indictment. Go to the Idaho Cases of Judicial Interest website. Scroll down to Idaho versus Kohberger. Go to May 16th, 2023. That is when the indictment was filed, and you will find it. And it says here, Brian C. Kohberger is accused by the grand jury of Latah County by this indictment of the crimes of burglary and the Idaho statutes that prohibit burglary. A felony, count 1, is located here. Then, the counts as to the students. If you read the indictment, you will see that the count number 2, unaliving in the first degree, relates to Madison. Unaliving in the first degree. A felony in count 3 relates to Kaylee. Unaliving in the first degree relates to Xana. And unaliving in the first degree. Count 5 relates to Ethan. We know that this is the order of counts 2, 3, 4, and 5. By looking at page 2 of this indictment, we don't know why the counts as to the students are listed in this manner. Now let's look at count 1. This is the first count listed here. Burglary. Idaho Code Section 18-401 and 18-403 is a felony. And you can look up these statutes on the internet by plugging them into any search engine of your choice. The indictment reads that the defendant, Brian C. Kohberger, on or about November 13th, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of unaliving. You see here at the bottom of page number 1 a redacted stamp in capital letters. The only thing that is redacted as you read this entire indictment is the signature of the presiding grand juror has been redacted. Above that signature line states the following: all of which is contrary to the form, force, and effect of the statutes in each case, made and provided, and against the peace and dignity of the state of Idaho. A true bill in capital letters, presented in open court this 16th day of May, 2023. And again, the signature block there. Note here The state of Idaho is specifically referenced. The state of Idaho is who is the plaintiff prosecuting this criminal case. It is not being prosecuted on behalf of any of the students, for example, by and through their estates, for example. It is being prosecuted by the people of the state of Idaho. Now, there's 5 counts, as we see here on the indictment. The state of Idaho has the burden of proving each and every count. The jury instructions, standard jury instructions for the state of Idaho, are located online. These were approved of by the Idaho Supreme Court. It must be noted that at all times Mr. Kohberger is considered not guilty of these very serious charges that appear in the indictment until or unless he either voluntarily pleads guilty or is adjudicated guilty at that future jury trial, which will commence August 11th, 2025. Now, unfortunately, the proposed jury instructions that both sides sent to Judge Stephen J. Hippler, which they were ordered to do by virtue of the court's order of October 9th, 2024, that set the time for the start of the jury trial, did not order them, either side, to file jury instructions under seal, but they did. And the court granted both sides' motions to seal their proposed jury instructions, as well as any objections or stipulations thereto. But if the members of the state and or defense submitted standard jury instructions as to, for example, the nature of trial, which is ICJI 101. You can find it on the website that I have recommended that you look at so you can see what standard criminal jury instructions say. This jury instruction instructs the jurors as follows. Now that you have been sworn as jurors to try this case, I want to go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I will give you more detailed guidance on how you are to reach your decision. So we can see that this appears to be a standard jury instruction once members of the jury have been sworn in. Then this jury instructions continues. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. Then, as this standard jury instruction tells us, the defense may make an opening statement as to what they believe the evidence will show or not show, or can wait until the state's presented the case. Then we see this jury instruction goes on to say the state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence, but it is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. Next. After you have heard all the evidence, I will give you additional instructions on the law. That is what jury instructions are. They are instructions on the law. After you have heard the instructions, the state and the defense will each be given time for closing arguments. In their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are the closing statements. After the closing arguments, you will leave the courtroom together to make your decision. During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. That is an instruction that's given after voir dire has happened. Here we see a standard jury instruction: consider each count separately. Recall, Mr. Kohberger is charged with 5 counts. This instruction says each count charges a separate and distinct offense. You must decide each count separately on the evidence and the law that applies to it, uninfluenced by your decision as to any other count. The defendant may be found guilty or not guilty on either or both of the offenses charged. Let's take a look at this standard jury instruction. And again, we're assuming that something like this will be used in the Kohberger case because there are 5 counts. Each one is separate and distinct. So the jury may find that Mr. Kohberger is not guilty of count 1, but guilty of counts 2, 3, 4, and 5, or vice versa. Because it says here the defendant may be found guilty or not guilty on either or both, this would need to be changed a little bit to reflect the fact that there's 5 counts of the offenses charged. Now, we will continue to keep you updated on further developments of the case. It is now still in pretrial, and there is a lot that still needs to happen in the next 3 months until voir dire, including the very important May 15th and possibly going into the 16th final pretrial conference. This may be the only pretrial conference that happens in this case. So I do recommend that you watch those proceedings. We are going to be having a live a few days beforehand to address the pretrial conference. And I hope that you'll join us here on YouTube. If you have any questions, comments, please leave them here. My name's Kathy. Thank you for joining us here today.